Hi, I'm Reed Bloodworth, the managing partner of Bloodworth Law, with offices in Orlando and Winter Haven, Florida. At Bloodworth Law, we handle probate and trust litigation for plaintiffs and defendants in Florida. Today, I'm going to talk about who determines whether a person is sound of mind or whether someone lacks capacity at the time estate planning documents are signed. This situation often arises in cases where someone is seeking to set aside a will or a trust. The answer is that there is no just one person who determines whether or not the testator or the grantor, the person who made the will or the trust, had capacity or not. However, the person challenging a will or a trust has to collect and provide admissible evidence to show at the time the person signed the will or the trust, they did not have capacity. They'll have to prove that during the moment when that person is actually putting the pen to the paper and there was a lack of mental capacity. Just because someone's very sick doesn't mean they lack capacity. There's an older Florida court case that states even though the person executing the will may be of great age, their mind is enfeebled, their body's debilitated, their memory's failing, and their judgment's vacillating, that a will can still be valid. As long as the will appears to be fairly made, it's not unnatural, and was made in conditions not inconsistent with inference that came from a person's free mind. The courts put a high regard on a person's properly executed will, meaning the testator signed it in the presence of two witnesses and it was notarized. There's a presumption that it's valid, and it's up to the person challenging that will to prove that it's invalid. In proving a lack of capacity, there are a number of things pursued through the discovery process of the case. This begins with the testator's, and now decedent's, medical records. Were they diagnosed with dementia or Alzheimer's? How bad was the dementia or Alzheimer's? How long ago were they diagnosed? Because both dementia and Alzheimer's are progressive diseases, they don't get better. Other things that will be looked at in a case for lack of capacity are witness statements, depositions. Time will be spent finding people that were around the person whose capacity is challenged. These are all used as evidence that the person did not have capacity to understand what they were doing when they executed the will or trust. Because when you create a will or trust, you need to understand what it is that you own, your belongings and your possessions, and what you're doing with them in terms of to whom are you going to give them. It's not just a collection of medical records. It's never that clear cut, because it all comes down to the moment the person actually signed the will or trust and the people that knew the true intent of the person signing that will or trust. Again, I'm attorney Reed Bloodworth, managing partner of Bloodworth Law. If you have a probate or trust litigation dispute, give me a call. Let's talk about how Bloodworth Law can help you or your family.